the Attorney General on forensic science at the Department of Justice in D.C. In that capacity, he serves as the department's lead advisor on all issues involving forensic science policy and practice. Prior to his appointment, Ted was chief trial attorney at the Jackson County Prosecutor's Office in Kansas City, Missouri. He's prosecuted well over 100 felony jury trials. He's a former member of the National Commission on Forensic Science, and he was a member of the AFFAS Board of Directors, the Missouri Crime Lab Review Commission, and the OSAC Legal Resource Committee. He is a fellow in the jurisprudence section of the American Academy of Forensic Science. And Ted is going to give us some information about what the priorities of the department are in the area of forensic science. And he'll also update us on the Uniform Language Project.
The focus from a policy perspective is on three what we consider critical areas. One is coordination and collaboration of forensic science, and that has to do with coordination inside the department, coordination across the federal government, and then greater coordination with state and local partners. Secondly, increasing the capacity of forensic service providers, the services that forensic laboratories provide to law enforcement, federal, state, and local to keep up with another of the department's priorities, which is combating and reducing violent crime. And third is improving the validity and reliability of forensic analysis. So first of all, in terms of coordination, collaboration, like I said, this is at all different levels within the department, across the government, and within our relationships with state, local, and tribal entities. One of the things that I walked into was the job and the title Senior Advisor on Forensic Science when this administration did not renew the National Commission on Forensic Science that I was a member of. The new Attorney General, General Sessions, created this position to come in and take a top-to-bottom look at the department's priorities, where we were in forensic science and where we should be going. So I filled that position. I've been at the department for about 2 years. I arrived in D.C. in July of 2017, so we're coming up on that 2-year date. This is the announcement that came out. In the coming weeks, the department will appoint a senior forensic advisor to interface with forensic science stakeholders and advise department leadership. This was put out on April 10, pretty much concurrent with the last session of the commission. One of the things that General Sessions decided to do and the department's Office of Legal Policy recommended was to continue and formalize a forensic science working group. And that's a departmental working group. It's chaired by me. We have department components, and that is government speak for different agencies within the Department of Justice who have different equities and interests in forensic science, have members who are a part of this internal body, and these are lab directors, these are folks who have policy positions, or laboratory systems directors. And generally speaking, we meet about once a month, sometimes more, sometimes less, depending on what's happening, and we address all issues of practice and policy, whatever might be going on at that particular time from a reactive point of view, and then proactively we have our major policy initiatives that we continue to work on. Another body that is new as of February of last year, February of 2018, is the Council of Federal Forensic Laboratory Directors, another acronym, CFFLD. This is actually not a new body. During the commission years, this was fairly inactive. But of all of the federal laboratory directors and system directors who have some interest or equity in forensic science, they have a seat at our table. And there's about 13 to 15 different federal entities that are a part of CFFLD. It is headed by one of our laboratory system directors, and the department, in terms of the department's leadership offices, at this time, the Deputy Attorney General's office, we have an ex officio membership to that body, as does the National Institute of Justice. It was first established by Attorney General Gonzalez back in 2005, and it's kind of the brainchild of the DEA at that time. It was again rechartered, like I said, last year by Dag Rosenstein and announced at the American Academy of Forensic Sciences meeting. And the first meeting was last May, and the second meeting was just this past May at the ASCLD meeting. So due to some staffing issues, this has been a little slow to regenerate and to get going, but the plan going forward is to have quarterly meetings at least. This is a body that is coordinated more or less loosely through the Deputy Attorney General's office. It's currently chaired by Greg Zarnopis, who is our ATF Laboratory Systems Director, who was designated by the Deputy Attorney General to that post. And we currently don't have a vice chair, but that is the next order of business. This will be a non-DOJ voting member. The mission is pretty straightforward and pretty general. It's to advise federal agencies with formulation and execution of national policies on forensic science. But I think most of all, it's a forum for consensus building and the exchange of ideas and interests and information regarding implementation of policies and practice. So just to get a little more specific about that, the body was created in its charter to advise particular federal agencies on issues related to the advancement of forensic science. And through the DAG, the CFFLD may respond to requests for assistance or provide consensus-based policy positions when it feels it's appropriate. But it's an autonomous body. It doesn't answer to the Deputy Attorney General's office, but we help to facilitate the agenda, add input, but it's not bound and beholden to that body or to that leadership office. It also provides federal agencies of the judicial or legislative branches and state and local jurisdictions assistance or practice or policy guidance as appropriate. So a very broad charge that is reviewed every couple of years. And like I said, a little bit slow getting started due to some staffing issues. But again, I think we are going to probably have quarterly meetings going forward. The topics are as general as the scope: forensic research, new and improved technologies, the sharing of potentially workloads or contracting out to other federal agencies work from another agency, discussions about quality assurance issues and how we can help improve our quality systems collectively across the federal government, education and training, consensus-based statements to the DAG, as I mentioned, and to other represented federal agencies when appropriate. Now, the kind of third leg of this stool, if you will, is a new body. This is the CFFLD, in addition to the CFFLD, what we call the Flynn TWIG, the Forensic Laboratory Needs Technology Working Group. And this is a group of about 15 laboratory leaders, and there's about 5 researchers involved in this project. So this is our contingent of state and local laboratory directors who basically come together, and the focus and the goal of this group is to try to implement new technologies inside crime labs. And there are some pretty exciting things. I don't know if you have heard about or talked about some of these yet, but there's some pretty exciting stuff that's on the horizon. The real trick, though, is to harness this type of technology that's ready to go, that's just ready to go, and then give it that little push it needs to get operational. And among these are 3D optical topography. NIST is doing some research on that along with the FBI firearms and tool mark section. There's a lot of work being done in latent prints in that area. And in addition to that, we've got some projects working in serology with the OCME that has some exciting new stuff that they have developed that we're trying to get into a wider national profile, being able through proteomics to positively identify body fluids is something that in litigation, as I experienced for many years, can be critical and key to issues in litigation. Many times the DNA is conceded, but the real question is, what is the source of this body fluid or this tissue? And this is an exciting advancement that we're going to try to push out there. There's also some work that we're doing in time of flight mass spec with regard to toxicology, digital forensics, and then cloud storage of information with big data coming in terms of DNA. Next generation sequencing is another topic that we're looking at, trying to handle, store, account for, and share that data when appropriate and when needed, and discovery and whatnot is a significant challenge because there's an enormous amount of data that is being and will be generated in the coming years. We're already getting to the point where we're having some real issues with, across the country that is, with storage of data, IT solutions, making sure that the IT infrastructure in our laboratories can handle the capacity, and then equally as important that we can collate, distribute, and use this information so that we can have statistics on various metrics that can help inform things like grants or help to try to isolate problems and put funding focally on those problems rather than just saying, well, I've just noticed an uptick in this type of case or this type of section in my laboratory. It really hampers strategic planning not to have good, timely data. And that's one of the challenges for forensics in the future, is to collect the enormous amount of data that actually gets generated, to analyze it and to use it for critical decisions, both politics, policy, operational issues, personnel issues, acquisition of instrumentation. All across the board running a crime lab, you need to have good, solid, recent information that you can use and share with others. So increasing the capacity of our forensic service providers is very important to us, both within the department and without. So one of the other things I want to talk about in that light is the status of the needs assessment for the forensic science community. The Justice for All Reauthorization Act of 2016 is the piece of legislation that mandated that the Attorney General conduct a needs assessment for forensic laboratories for study and report. Not later than October 1, 2018. Well, October 1, 2018 is in the rearview mirror and it didn't come out. So what happened? We ran into something you might have heard of, the government shutdown. And that put the brakes on this project for well over the month that the government was shut down. We also had some issues with our technical writer who had some health problems. So one thing led to another, and we're still behind the curve. The good news is, even though this didn't come out last fall, I think the report is going to be much improved because of the extra time that we've had to go through this report and to make sure that all of the statements and claims in the report hit the mark. And Jonathan McGrath is here, who worked on that report there in the back, along with a few other people. So he did a lot of the heavy lifting on this, as did other folks at NIJ. So we're indebted to their work on this. I've seen a couple of drafts of this report, and I think it's going to be a different kind of report about forensic science than you have seen in the past. There's been a lot written, and I think appropriately so, on issues about transparency and quality and accountability and scientific rigor and so forth. But what really hasn't been looked at in depth is when you walk inside a crime laboratory, what are the daily challenges they have to just simply function and to put out a quality product at an enormously breakneck pace to try to keep pace with the crime rate and the demands of investigators, prosecutors, and defense attorneys alike. How can they do their job from hiring, from retaining people, from some of the IT issues we talked about, training to competency to proficiency, managing all of this within a quality framework and making sure that we do it quickly, but we don't hurry in the sense that we don't get it wrong. And there's some enormous operational issues that have never been talked about in a report of this nature that I think will be eye-opening for some, but I also think it's going to bring a different perspective and a greater appreciation for what crime labs across the country actually have to face on a daily basis, and can start that conversation at a national level about some things that we can all do to try to fix some of these problems and issues, because we all, no matter what side of the bench or bar we're on, we need healthy, fully functioning crime laboratories. And I think we can all agree on that for sure. But the report has a couple of requirements. The charge was to examine the status of the current workload, backlog, the personnel and equipment, and the equipment needs for the future in public crime labs and medical examiner and coroner offices. And the report is to include an overview also of the academic forensic resources and needs, many of the things that have been written, the reports, the studies in the past, from a broad perspective, including non-traditional forensic sciences, some of the, call them affectionately, oddball forensic sciences like entomology that are very important in particular cases, or forensic anthropology, things of that nature. So that hasn't been forgotten. There were some documents that the department was to take special note of, and those are spelled out in the legislation here. Forensic Sciences Review of Status and Needs, a report published in 1999. The Bureau of Justice Statistics Census Reports, the latest of which many of you know was published in 2014, and there were editions of that published in previous years. Every 4 or 5 years, one of these censuses comes out again. The NAS report from 2009, of course, and then the Bureau of Justice Statistics Survey of Forensic Service Providers recommended by the National Commission. Has anybody read that? I guess none of us have, because it never happened. So this got put into legislation, but the report was never completed. And it happened before I got to the department, so I don't know the backstory on that. But at the commission, we were requesting a more in-depth study, particularly to find out, other than crime labs, there are a lot of forensic units out there in the country that may be a part of a police department doing latent prints, or maybe there's a firearms and tool mark examiner that's part of a police department, not inside the quality assurance envelope of a laboratory, but we just don't have a real good handle on how much forensics is being done outside of the crime laboratory proper. And that was the idea of that report to be, which had not occurred, but hopefully over time we will get a better handle on those numbers. Other topics had to do with infrastructure, equipment, personnel needs of the broader forensic science community. So these issues I mentioned already, infrastructure, equipment, personnel, getting somebody in, trained, up to speed, and a fully functional forensic science is an enormous undertaking. I don't think people fully appreciate and realize. Starting with the background review, all the way up to hiring and then retention. People who might get trained in a laboratory might leave and go to a higher paying jurisdiction. So that whole process starts over again, and you've got the sunk cost effect of training those folks up to competency and leaving, and that unfortunately, is a reality when the jobs are plentiful, but we just don't have enough candidates who meet all of the requirements to actually get hired and then are retained and trained up to competency. And of course, this will be made available to the public. This will go to Congress, to the House and Senate Judiciary Committees, and then, of course, to the public at large, so you all have a chance to read through it. We did some listening sessions, as we call them, as a part of this project, and these are some of the groups that we met with. We tried to get a wide range. Of course, you're not going to get anybody and everybody that you try, but we did our best in the time that we had to make the rounds, so to speak. We talked to the forensic toxicology community, IAI, International Association for Identification, had a large meeting with the medico-legal death investigation community, ASCLAD, had a great session with them. SWIG-DE is the Digital Evidence Forensics Scientific Working Group. Had a great meeting with them. We talked to attorneys and judges in February of 18 at the American Academy of Forensic Science meeting. And IACP, International Association of Chiefs of Police Leaders, FEPAC, the Forensic Educators, and federal lab directors as well. So we got a lot of input from a lot of people. We also had those documentary sources and the charge otherwise as it related to what we were supposed to look into. One of the things I wanted people to know about was the Rapid DNA Act of 2017. You might have heard about rapid DNA over time. And the FBI in particular is going to roll out rapid DNA in the coming years. We're in the pilot project phase of this rollout, where there'll be about 5 states that we're going to use as our guinea pigs. And the idea is to go to, first of all, the crime labs and establish that rapid DNA is a workable solution inside of crime laboratories, and then roll it out to the field. To do it right is painfully slow, but responsible at the same time. So over time, this will slowly grow across the country. It'll be very interesting to see how this ultimately plays out and what some of the benefits and the detriments are to doing this. There are always sort of unseen problems to troubleshoot over time, and we'll tackle those as we come to them. But that is a long-term project that we're going to engage in. I'm going to skip over some of these slides that kind of get into the minutia a little bit, but one thing that I think needs to be made clear is by federal law, we have to do things in the right order. Just because rapid DNA is available doesn't mean that police departments can automatically come online and start using it on crime scene samples and so forth. We have to be responsible about that. So we want to make sure that everything's in place. We've got rapid DNA instruments that have to be approved by the director of the FBI in compliance with the standards and procedures issued by the director. And for rapid DNA to work, that means the instrumentation has to be carried out in a fully automated manner, from extraction, amplification, the separation of the fragments, their detection, and the interpretation, with no human intervention, and we call that lights out DNA processing. So the interpretation piece is not fully there yet. So until that happens, we're going to have to remain in a modified state with regard to rapid DNA. And we have to have standards and procedures for rapid DNA that are approved by the director of the FBI by statute. So that all takes time. Skip through a little bit of this in terms of the roadmap. We've got the pilots coming out. We've got to draft authority to operate rapid in booking stations. 2018, this is a little bit behind the curve. Our timelines haven't completely been met, but We have Arizona, California, Florida, Louisiana, and Texas on board to be our pilot sites. Okay. In terms of increasing the validity and reliability of forensic evidence, I wanted to talk a little bit about some studies, very long-term studies that are underway at the FBI. We call these decision threshold studies. Decision threshold studies are sometimes called in other contexts black box studies, but these are studies that actually happened and were in the planning stages before the PCAST report came out, and they continue to move their way through the process. So basically we're talking about firearms and tool marks, shoe print or footwear identification and document examination. And the idea is to use some really discipline-wide studies, and these are going to encompass federal, state, local, and private practitioners. These are going to be very large scale in nature. They're going to involve hundreds of examiners, thousands of samples, over 10,000 individual decisions. It's going to be a fully open set design. It's going to be biased hard, and it's going to be multi-year. So trying to make these very difficult samples to grapple with, to really kind of get kind of the upper end of what you might call a false positive rate, to see what kind of variability we have between examiners, but also, as importantly, to see across different laboratories, who's getting it right, who's getting it wrong, and what is the point at which you start to go into the false positive range, given some of the patterns that we're going to have studied. So it's multi-year. I don't want to say too much about it because this is a long-term project that is in process, and certainly when it's completed and all the data is crunched, this information will be published for everybody to see. Uniform language for testimony and reports. We have currently 14 published uniform language documents, and we have a number of others that are under development. So if you go to the department's website, www.justice.gov/forensics, you will see a forensics page that is housed in the Office of Legal Policy, and then you have a menu there that you can click on and see all of the resources that we have. So the idea behind these documents is that they be technically or scientifically justified. We're going to make sure that they're bounded and people are not saying things beyond the scope or the ability of a particular discipline or the evidence information in a particular case. We've got to make sure that we're not going beyond those limitations. Another interest is to make sure that the probative value is correctly formulated, and I think is importantly that is communicated in an understandable way that's comprehensible to the trier of fact. So we're shooting for uniformity in language and testimony reports so that somebody at the FBI is providing a conclusion on a particular point, just as that same type of discipline examiner at ATF. They're using the same terminology. They're defining that conclusion the same way, and they're providing the same basis for that. We want to make sure that we have consistency between forensic examiners in the same lab, that consistency within the lab, and then that consistency across laboratories in terms of what we're saying. And we do think this is going to enhance the quality of testimony and our reports. This is a little bit of a graphic that kind of shows you the outline of what we're talking about here. We've got an application section. We've got a purpose and scope section. We have the conclusions themselves. Typically, we have a relatively short definition of the term. And then we have a paragraph below that that sets forth the basis for the conclusion and, if appropriate, a statement of how to articulate the weight. Finally, there are qualifications and limitations in terms of what must be stated and what must not be stated. So I call these the thou shalt, the thou shalt nots. We don't want to continue to use some of the terminology that I think was unhelpful in forensics in years past, and that has led to, at best, some confusion. Things of this nature that if you look in case law, it's not rife in case law, but you find it. And I actually did a little study on this. You see some of these words and terms being used. And one thing that I've noticed is that in the last 5 or 6 years, there's really a precipitous drop-off in things like the use of the term no error rate, 100% certainty, claims of universal uniqueness, individualization have kind of gone by the wayside, and I call those quantitative sounding qualitative terms. Terms that sound statistical, but they're really not. And they're not, by and large, helpful, and they're not needed. So we're going to try to stay away from some of those, and we're going to try to clearly state what we mean so that nobody is misled. So if you take a look at the uniform language, it's very explicit about what we're saying, what we're not saying, and the basis for what we're trying to do. The latent print ULTR was the first one that was approved and announced by Dag Rosenstein. It and the other 13 documents are available online. Conclusions, and just using this document as an example, are examiner decision-based. There are propositions used, as Hal mentioned, and we're talking about the strength of the evidence as perceived by the examiner in support of one proposition or hypothesis versus another. Source identification is the term that is still used, a statement of the examiner's belief, but we're careful to say it's not statistically derived or verified by measurement or comparison. And the basis for a source identification is a logical, evidence-based inductive inference, and like any inductive inference, it's fallible. We could be wrong. We're not claiming that we can't be, but if you look at the examiner's record, they've proved over the course of their training up to competency and proficiency that they can source identify question marks to known sources. So this is a skill-based inductive inference that certainly is fallible. We know that because we have false positives from 1 to 1.5%, depending on your discipline, based on the few existing black box studies, but those numbers for the other types of studies that may not be fully open, maybe closed population studies, also are around that 1% false positive or less. So we got a pretty good measure of, most of the time, examiners in these pattern or feature comparison based disciplines, vast majority of time they get it right, and then when they don't, they're erring on the side, as Hal demonstrated, of false exclusions, which is where we want to be. If we have one type of false finding, we want it to be false exclusions instead of false inclusions. And I think what happens in practice is when examiners are unsure, it goes into the inconclusive bin. So I think there are many findings that are close calls that get ruled inconclusive. And I think another thing that was interesting about some of the black box studies is that many of the errors are happening by a small number of individuals. They're really not spread out over the whole community. So it's true there are some folks who are more proficient and better than others when it comes to their craft. So the qualifications and limitations part of these documents addresses some of these troubling words and phrases that I mentioned. Individualize and individualization, really not a helpful term. I don't think identification in terms of source ID is what we use. Some of these have been used. I think I traced this back to the early 1960s and trying to figure out where that came into practice. And one of the forensic forefathers, Paul Kirk, actually promoted the use of that term to distinguish it from identification. 100% level of certainty, obviously nothing in science is certain, and I think there's a conflation sometimes of somebody being personally sure of something, which is hard to talk somebody out of being personally sure of something versus the certitude that science can show. Certainly nothing certain in science, but when somebody has stated 100% certainty, I think we're all 100% certain about certain things. If we were to put a number on it, probably wrong. But I think there's sometimes some conflation about what we're talking about when we talk about certainty. But in any event, I don't think it's something that is helpful. Infallibility or zero error rate, obviously, again, is not something that science can or ever will establish. Nothing and nobody is infallible. And that much is certain. Now, there's a lot of debate over what an actual error rate is or might be, or whether you can even calculate one, but I think we can all agree on the fact that a zero error rate is something that does not exist conceptually or practically. And then again, the number of examinations performed is not a proxy for the accuracy of the result in the instant case. Sometimes in some old examples, an examiner would say, well, I've done this for X number of years, and I've always been able to tell a question from a known and part. If you threw them into a pile, I can pull out the question and take it away from the known. Or if there were two different types of samples, one from one person, one from another, they could always distinguish those. Again, not helpful. A reasonable degree of scientific certainty is something we talked about at the commission at great length, and then finally the Deputy Attorney General. And actually, I think the Attorney General came out with a memo, said that the department would discontinue the use of that phrase. So that's been department policy for over the last couple of years. Testimony monitoring, I'm told you heard about that yesterday from Paula Wolf. I just want to briefly cover that. Testimony monitoring is designed to be a quality assurance measure by department laboratories and digital analysis entities. So the idea is to catch and quickly correct any misstatements, overstatements, or any type of conditionals. For example, in a likelihood ratio, if you've got a misplaced conditional and that's stated, we want to make sure that we correct that because it has to be technically correct. Will the jury go ahead and transpose the conditional? Well, they probably will, but we have to make sure that we don't do that and that our prosecutors don't argue that. So I think spending some time on LRs is critically important because we are moving that direction, and I think we'll move that direction over time more and more. I got to make sure that slips of the tongue, whether they are purposeful or inadvertent, and I think the vast majority of the time these are going to be inadvertent slip of the tongues, but if you've ever testified like I have, you go back and you read your transcript. Anybody ever done that? You're like, I didn't say that. You go into a zone when you're on the witness stand and you don't realize what you're saying and how you're saying it. And I've just been incredulous. I didn't say that. The court reporter must have got it wrong. Well, whether they did or not, it doesn't matter. It's in the record, right? So you can't go back and relitigate that. But the point is, we have two ways of going about this. We've got transcript reviews we're trying to do within about 30 days. So after somebody testifies, we're trying to get the transcript, get it back, review it in about 30 days. That depends greatly on the court reporter, how busy they are, how many calls we make and how much we bug them. So that's one method. And the FBI has done that and caught a number of errors in recent times, specifically about the transposed conditionals with the onlining of star mix and getting used to stating a large correctly. It's far from intuitive for most people. The other way we can go about that is by having in-person monitoring. And actually, the beautiful thing about this is that ANAB and the other accreditation bodies that are out there, A2LA, for example, testimony monitoring is required as a part of the supplemental. So it's already built into the accreditation process. We just put some more meat on those bones by formalizing this and making it a bit more rigorous than accreditation requires. So it's already worked. We've already caught some mistakes. None of them were major, and none of them were verdict changing. I don't think new trials were granted in a case, but the important point is that we caught them. And the right thing to do is to disclose them and let the judge figure out, after hearing from both sides, whether that misstatement was material or not. And in one case, the misstatement was based on testimony that was provided by an examiner for a defense attorney. So it works both ways. We made that notification as well. So these are the goals. We want to highlight opportunities for continual improvement. So I think the bottom line here is really the bottom line. We want to make sure that this is a quality assurance measure, and we want to make sure that it's something that folks embrace and don't look at this as a game of gotcha. That's not the intent at all. The more feedback you get, the better you're going to be, and the more you're going to realize things that you didn't know. If you've seen yourself speak publicly, and then you go back and you watch the tape, you just think, I didn't say that, or I didn't use those mannerisms, or I didn't say that word. And we all have little things that we do while we speak that might be fixed, cured, or improved by that feedback. And that is traditionally one of the places that forensic examiners are kind of out on their own historically. You go to court and you're away from the lab, and you got all this work that you did, and you're translating that for the judge, the jury, the parties, and nobody watching back home, right? So now we're taking that quality from inside the laboratory and putting it outside the laboratory, either through a transcript review or through in-person monitoring. So nobody is ever truly out there on their own and not realizing what they may not be doing along the way. The evaluation phase, and this is all online, by the way, you can go check this out. Our framework is online, and based on the framework that the Deputy Attorney General approved, each of our laboratory systems created their own policy that is consistent with the mandatory points contained in this umbrella policy or this framework. So each one of them has created the specifics that only an operational laboratory can do, given its people and its resources and its structure. But the evaluation is all the same. The testimony has to be consistent with mandatory policies and procedures regarding analysis of evidence. The opinions, conclusions, and statements about case-specific facts and data have to be properly qualified and not exceed the limitations of the method performed or the discipline in question. And the conclusions must be in conformity within a uniform language document. Another thing that we have done, this is about a year old now, is we posted online all of our laboratory documents, our quality assurance documents. So our quality management system documents, quality manual, for example, our testing, analysis, and examination policies, or our SOPs, are all online, and existing validation study summaries are all posted. So there's an enormous amount of information there for the public to see, for litigants to pull up and look at. I use them myself when I have questions, when I need to have access to those documents. I don't have any special way to get them. I just go online and print them off if I need them, or reference something and take a look. So each DOJ laboratory component that has a laboratory or digital analysis entity has posted these. It's the current version of the document, so we don't have archived versions up there. However, in litigation, if that's requested, that will be turned over, and I think the FBI, for example, turns those over anyway. The time frame specific SOPs and existing quality documents from that time frame, when the testing was done, gets pushed out along with the rest of the discovery. And of course, if there is a supplemental or additional or more in-depth request or response, we will take a look at that and respond in kind. Most likely that will all be turned over. So these have all been online since around last spring or summer. We had a little bit of a technical issue, so I think spring kind of stretched into last summer, but they're all up and running at this point in time. And we think that the principles and the utilities involved here, number one, transparency in science is very important. That's a core scientific value. It makes discovery and disclosure so much more efficient. We can just say, here's the website, they're all there, go online. If it's a current case, if it's a past case, then those archived documents would be provided. And the sharing of high quality, we believe high quality SOPs helps quality promotion, and for people to take a look at what they're doing and compare them to what we're doing and see what they might borrow from us, I think is a good thing. One of the things I wanted to mention, because I know there's some people here interested in this, is the PCAST report and the attempt to amend Federal Rule of Evidence 702. I wanted everybody to know this is ongoing right now in the judiciary. There is a lot of discussion about Rule 702 as well as Federal Rule of Criminal Procedure 16. And in these meetings, forensics is featured. So going forward, this will be a topic for discussion. We have sometimes different points of view about the existence of the problem, and then if we agree to a problem, how that should be best remedied. But this is something that's currently happening right now and will continue probably for some time. Largely, the PCAST report is cited as a reason that this is needed. And we've had a lot of discussions since about fall of 2017, when we had a mini conference at Boston College School of Law about this topic. And there was actually a mini conference recently in DC. The Federal Advisory Committee on the Criminal Rules met and had a mini conference about Rule 16 and the extent of discovery that should be turned over. But at least at the federal level, at the department, we've got a lot of stuff online, and we're trying to be as transparent as we can about stuff that we push out when we get discovery requests. We make every effort to try to disclose that which is requested, and if there's some type of problem where we can't, we certainly notify the U.S. Attorney, and they have to argue that point in court. But I think the vast majority of the time, things do get turned over in a full and complete manner. So I think that's basically all that I had prepared. If anybody has any questions, I can take a couple. If not, Matt, when's our next speaker?
I'm going to check with David and see if he needs a break or if he's ready.
I don't think we should take a break. I think we should try to leave on time.
Okay, good idea. All right, yeah, Jim.
So just one question. First of all, Ted, thank you for that review. It's very informative for me because, you know, I want to keep looking in. But you made this one point about these long-term reviews, and you said that you couldn't give a real finite time frame, but what sort of is the general sense about that?
The decision threshold studies or which?
Yes.
Okay. I've asked that question, and the answer I get is we don't know. It just depends. Like I said, these are huge studies, and I think the first time this was publicly stated was at our mini conference on 702 at Boston College School of Law. I think our deputy assistant director, Al Seisenberg, mentioned the fact that we're doing this, and when I came on board, I got briefed on it 2 years ago, so they're still in process. Some are further along than others, but we try to say as little as possible about that because we want to make sure that the examiners that are taking these examinations don't say, well, you know, this is a study that I heard about. We want to make sure that we're not giving too many specifics about this, so want to maintain the integrity of these, but some are farther along than others. It's a multi-year process, and when it's done, I think we're going to really have a really good idea of what these false positive, false negative rates look like in these various disciplines. So I don't have an answer. It's kind of one of those things, you know, when you have a massive project, it'll be done when it's done. We're not trying to push it until the time is right. So. But you'll read about it.
I'm sure. Thank you.
All right. Anybody else have any questions?
So, what have you found to be the needs of forensic labs for the DOJ, and are you going to provide them?
The report
What are you going to do to provide for those needs for the forensic labs?
Well, first of all, the report will be publicly available. The way to address each need is going to depend on the need, and obviously, like anything in life, it's going to depend on available resources. My hope is that because this is going to Congress will see that there is this problem that they never knew existed. They've heard about certain types of problems in forensics. The real, day-to-day, existential, operational problems have never been spotlighted. They were referred to a bit elliptically in the NAS report, but this really hones down on that issue. So again, my response to your question is it all depends. I don't know. It depends on funding. The point is to make sure that they understand that quality can't be sacrificed. If we want to have a quality system that ensures integrity of results, we have to make sure that it has the proper funding. So one of the points of this, hopefully, will be to wake some people up to the need for sustained funding for crime labs.
So it seems like a lot of these efforts are trying to get at kind of errors that might occur in the as-applied stage of forensic testing, and I'm wondering if your commission and your group is also thinking on exploring the actual foundational validity or kind of the soundness of some of these forensic methods as a discipline.
Well, I think the decision threshold studies, in fact, if you read the PCAST report, they say that is the way to establish foundational validity in subjective feature comparison methods. So that is ongoing, and I think you will see further studies of this nature in the future. So I guess the answer to that question is we got to see where we're at first. As I said, these are biased hard, and they're going to involve thousands of decisions and thousands of examiners. We're going to have a really good idea about, in terms of that type of foundational validity, what the false positive, false negative rate is, and where people are putting hard decisions. Are they putting them in the ident category, the exclusion category, or are they going in the middle and inconclusive, where I think some studies have shown that's where a lot of stuff goes in the middle.
Okay, thank you.